Welcome to everyone to this afternoon keynote panel, which I'm really looking forward to, despite possibly quite a grim topic. Thanks to everyone who's been speaking so far today. I've really enjoyed the papers so far, and of course, thanks to the organisers of the conference, which is running extremely smoothly. Today's keynote panel is Political Investigations, Legal Archives and Women's Testimonies of Sexual Violence. And we have kind of a three-hander here. We have Professor Jane Allmeyer from Trinity, Professor Rosemary Byrne from NYU Abu Dhabi, and Professor Stephanie McCurry from Columbia University. And they're going to kind of weave in and out of one another's talks, and then following their piece, we'll have a conversation about the paper. So make sure you put in any questions that you have into the chat, and we'll ask the questions of the speakers at the end of their presentation. I'm just going to introduce everyone all together first. Today we have Jane Allmeyer, the Erasmus Smith Professor of Modern History in Trinity College Dublin. Her work specialises on early modern Irish and British history, and her many publications include the monograph Making Ireland English, the Irish Aristocracy in the 17th Century. She's currently delivering a brilliant Ford lecture series at the University of Oxford on the subject of Ireland, Empire and the Early Modern World. She's editor of Volume 2 of the Cambridge History of Ireland, and she led the 1641 Depositions project at Trinity College. She's chair of the Irish Research Council, former vice provost for global relations, and director of the Trinity Long Room Hub Arts and Humanities Institute. And she's currently one of the 3 candidates for provost of Trinity College Dublin. So we're wishing her all the best in that race. Our second panelist this afternoon is Rosemary Byrne. Ms. Rosemary Byrne, Professor of Legal Studies at NYUAD. She's a graduate of Barnard College, Columbia University, and Harvard Law School. Her academic and policy career has been in the area of international human rights, with particular interest in international refugee and EU asylum law. She served as Human Rights Commissioner for the Irish Human Rights Commission, which was established in the aftermath of the Good Friday Agreement, and went on to chair the Scientific Committee of the EU Fundamental Rights Agency. Previously worked in the law faculty of Trinity College Dublin. And our third panelist, Stephanie McCurry. Professor Stephanie McCurry is the R. Gordon Hoxie Professor of American History at Columbia University. Her research focuses on the American Civil War and Reconstruction, the 19th century United States, the American South, and the history of women and gender. Her books include Women's War, Fighting and Surviving the American Civil War, which was published in 2019, and Confederate Reckoning, Power and Politics of the Civil War South, published in 2012, which was a finalist for the Pulitzer Prize. She's also interested in the comparative history of post-war societies and the processes of reconstruction in the 19th and 20th century. So great range of time periods and expertise here. So we're really looking forward to this session. I think Jane is going to start us off.
Thank you very much, Clodagh. And I mean, it's just so lovely. I wish we were doing it in person, but anyway, it's lovely to see you online. But also a big thank you to Mary and to Fionnuala and to the whole committee for this invitation, but also congratulations on the conference. The programme is fabulous. So well done to everybody for just making the best out of a not great situation. It is a bit of a relay race. Just to give you a little bit of context about why Rosemary and Stephanie and I are working together. So Rosemary and I were colleagues in Trinity, and I miss her very much indeed. But when we were together, Rosemary was working in human rights and I was interested in the depositions. So we've been having a bit of a conversation on and off about this for a long time. And then I became director of the Trinity Long Room Hub, and I had the privilege of really starting to work much more closely with colleagues at Columbia University Trinity and Columbia developed a 2+2, an undergraduate program. And on the back of that, we wanted to build research collaborations. So the hub teamed up with the Heyman, which is the sister institute in New York. And through Eileen Galuli, the director of the Heyman, I got to know Stephanie McCurry. And it's been, again, just a fantastic a friendship thereafter. But Stephanie and Rosemary and I all got to know each other really well indeed in the context of a project called the Crisis of Democracy. It was an initiative funded by the Mellon Foundation through the Consortium for Humanities Centres and Institutes. And we had a 2-week summer school in Dubrovnik. And we were all sort of together, very intense, lots of long bus trips across Croatia and into Bosnia. And we really started to talk in a very deep way about the interests we all had in women and sexual violence. And so this paper really has come out of that friendship and collaboration. It is very much a work in progress. So big health warning, folks. This is, I was going to say the world premiere of, that's not strictly true. We did deliver a workshop on it a year ago when that was the last travel I did, is that last February went to Rosemary to NYU Abu Dhabi. The three of us then presented it at a workshop there. So it's the second time actually we've come together to talk about this work, and we're particularly delighted it's here because we know that we'll get lots of really constructive feedback. You're our critical friends. So I suppose just by way of introduction, what became very clear to us is that our work on sexual violence had much in common. We all work on legal archives, albeit in very different periods, very different geographies. I work on 17th century Ireland, Stephanie on 19th century America, and then Rosemary on 20th century Rwanda. But we were all very focused on the ways in which sexual violence was and is used for political ends, and how it shows up in different legal fora, and why sexual violence was and is so effective in instilling terror. So why, we asked ourselves, is it important to ask these questions in a collaborative way that cuts across time periods, cuts across national histories and disciplines? What can we gain by looking across time and space? And what has been lost by focusing on the relationship between sexual violence and political terror in particular regions and in isolation? So all of these questions, and the truth is we've been mulling on them over a long period of time here, but we very much hope that such an approach will be generative to the analysis of sexual violence in a political context by undercutting any imputation of exceptionalism to show instead a pattern of sexual violence that is foundational in and to political conflicts, and I would say especially civil wars. So our presentation this afternoon draws on 3 very different case studies, and this is where I'm going to come to our slides, which I'm going to show you and then, as I say, switch them off. But the first case study is, of course, that of 17th century Ireland, and Clodagh has already mentioned the 1641 depositions. They comprise over 8,000 witness testimonies, examinations, and associated materials in which men and women, about 10% of the deponents were women of all backgrounds, but predominantly of the Protestant religion. There are some Catholics. Told of their experiences following the outbreak of violence on the 22nd of October, 1641. The depositions were used in the war crimes tribunals established by Oliver Cromwell, but also in later courts. And then in 2010, we published the 1641 depositions online. And as some of you will be aware, the Irish Manuscripts Commission is currently publishing all of the volumes in hard copy. And I simply want to acknowledge the passing of Aidan Clark, who was, of course, the genius editor behind this project, who we lost back in December. But really, the Depositions is so much a tribute to Aidan Clark. What you see in front of you here are the Depositions in their original 18th century binding. They have since been rebound and, of course, digitized and available online. So almost immediately, the Depositions started to be used for propagandistic purposes. And this image will be familiar to many of you because it's from a 17th century publication called The Tears of Ireland. And these woodcuts immediately illustrate how Protestant propagandists exploited the trauma, especially sexual violence against women, for political ends. And you can see here how this group of naked women who had been stripped of their clothing are being literally rounded up by the insurgents and being drowned. So that is our first case study. Our second case study takes us across the Atlantic and across time to the United States, or colonial America, the American congressional investigation of the Ku Klux Klan, which dates from 1871 to 1872. It contains 586 testimonies, some of which were used in court, and they include the first civil rights cases ever brought in the United States. And this is a picture of some of the 13 volumes of testimony the Joint Select Committee produced, and one volume trial record. These are for the state of South Carolina, where newly emancipated Black people were terrorized by the Ku Klux Klan, paramilitary organizations of white people determined to maintain racial dominance. This image shows Klan attackers in typical homemade disguise. Victims sometimes identified them anyway because it was very intimate violence involving neighbors upon neighbors. This brings me now to our third case study. And here we have an original trial chamber judgment. And of course, the archive that we're talking about here are the testimony and judgments from the International Criminal Tribunal for Rwanda, established in the aftermath of the 1994 genocide. This is the first time an international court had ever tried and ruled upon crimes of sexual violence in a civil war. The judgment not only provided the first definition of rape in international law, but also the first recognition that rape can be a tool of genocide. And this was a historic moment for the law relating to sexual violence in conflict, and a seminal moment for feminist scholarship, and something that we'll be coming back to. But I just want to close sort of the visual part of our, or what I want to say today, by sharing with you this montage, which is part of a commemoration of the victims that is displayed at the Kigali Genocide Memorial. Anyway, we're not going to show you any other visuals, but I hope that we've given you a flavor of just how powerful they are. And it's so awkward and clumsy with 3 speakers and lots of slides. So the rest of our talk is very much just us. But I suppose what I just want to say before I hand on is that each of these events, each of these case studies, produced a substantial archive of materials, including on sexual violence and political terror and civil conflicts, that has been mined by feminist scholars. We define sexual violence simply and broadly, drawing from the definition adopted by the Trial chamber in the Akayezu case as any act of a sexual nature in circumstances that are coercive. I want to make a few general observations on the forms of sexual violence across the three cases. We note as a baseline an interesting number of commonalities, even over 4 centuries. We see repetition of acts of stripping, whipping, genital mutilation, castration, rape, gang rape, but also sexual humiliation and degradation, including spectacle performances. These occur across time and across place. Such acts of sexual violence in political conflicts involved male perpetrators and female victims, but also male victims and female inciters. Testimony of sexual violence is cloaked in euphemism and requires contextual readings. And it's very important to note this isn't always captured in digital searches so it's incredibly important always to read the 1641 depositions. That's really what I'm trying to say. There's no substitute. You cannot just do word searches. What we notice, the persistent similarity, is in terms, some of which repeat. So words like stripped, ravish, and then had their way with me, did scandalize me. And we've also seen how contemporaries describe the spectrum of sexual violence ranging from humiliation and degradation to genocide. Now, of course, much of this is a work in progress. We are still, for instance, in the process of figuring out what bodies of literature bear out our research questions. One preliminary observation, however, concerns the focal point of the Rwandan discussion, and that's the 1998 John Paul Akayezu trial, where the International Criminal Tribunal for Rwanda convicted a mayor of a Rwandan commune for rape as an instrument of genocide and a crime against humanity. The recognition of sexual violence in armed conflict by the United Nations and international criminal courts opened a new era of accountability for rape, including by feminist historians who used that recognition retrospectively to recover evidence and to write new histories, including of 19th century America. In other words, taken together with the former Yugoslavia, the Rwandan case that is one subject of our study carries outside significance in the way feminist scholars use it to reflect on the analysis and theorization of earlier conflicts, though possibly at risk of interpretative damage, a point we'll come back to in the conclusion. Now, there are, of course, very significant differences between these cases, which we'll also get into and we can explore further in the question and answer. But let us begin with the remarkable and analytically productive similarities that come into focus across time, place, and context. And with this, I'd like to hand over to Rosemary.
Thank you, Jane. First, I want to talk about the kind of primary pattern that comes into focus about the nature of the inquiries that we're looking at and the production of the archive. And in that regard, we note 3 things. 1, in each case, the inquiry or the investigation is a mechanism for a broader political project of external actors. And this is because we're really dealing with mass crimes that by definition, require investigation by non-locals, in part because too many local people are implicated as perpetrators, and on account of the breakdown of the rule of law that often accompanies a commission of extreme crimes that occur across sectarian and ethnic divides. And this also exposes the limits of the local fora where the pursuit of truth or justice for victims of atrocities would be somewhat futile. So these inquiries and trials that are conducted by external actors, thus are interventions that are designed to serve broader political objectives. Two, to our second point that we note, is it's clear from the evidence produced that the fact-finding processes that we're working with primarily serve this broader political project. And three, in each case, the inquiry or investigation itself is linked to other legal processes, usually trials. So let's look at each of these shared features in the specific context of our first case study. So from the 12th century, back in time, Ireland was England's first colony. From the early modern period, Ireland formed an integral part of the English Empire and experiences periods of intense colonization. And the 1641 rebellion was an attempt to reverse this. So the 1641 depositions or witness statements were assembled in two phases with the explicit purpose of recording losses suffered by the Protestant community and amassing detailed evidence to justify the retribution that would follow once the state had reestablished control in Ireland. So the first phase of the collection began in December 1641, when the government set up a commission for distressed subjects led by 8 Church of Ireland clergymen and charged it with collecting statements from refugees who fled to Dublin. The later phase of the collection dated from the 1650s or the Commonwealth period, when a group of more than 70 commissioners spread throughout Ireland, gathering evidence against individuals who were accused of acts of murder or massacre allegedly committed during the 1640s. And these men and women were tried in newly established high courts of justice or war crimes tribunals. And so we cross time in the Atlantic to our second case study. The investigation of the Klan was launched by a joint committee of US Congress in 1871, and it followed the defeat of the Confederacy in the Civil War, the emancipation of 4 million enslaved people, the enfranchisement of Black men, and the backlash. 3 years of white supremacist violence against African Americans and their white political allies in the Republican Party in the southern states. Just a reminder that party identities were reversed in the 19th century, and it was the Republicans that were the progressives on racial questions. So an estimated 20,000 Black people were murdered by the Klan, and a vastly larger number were maimed, raped, tortured, and terrorized. It remains the single most significant domestic terrorist movement in US history. And after hearings in Washington and in various sites across the South, the committee produced 8,000 pages of testimony, most solicited to support the Republican majority's case, which was that the Klan constituted a widespread political conspiracy, that its object was to deprive African American men of their new constitutional right to vote, and that it warranted federal intervention to enforce civil and political rights of citizens. The new Ku Klux Klan KKK Act authorized the use of the military, suspension of habeas corpus, and trial in federal courts because of the, quote, willful connivance of civil authorities in the crimes. It was the first hate crime legislation in US history, and it's still used today. The investigation established grounds for the newly founded Department of Justice trials of Klan members starting in November 1871. And so our last case study emerges a century later from the context of mass and systemic sexual violence during the 1994 Rwandan genocide, during which 800,000 Rwandans, mostly Tutsi, were murdered, and an estimated 250,000 rapes occurred in the course of 100 days. And in November 1994, the Security Council established the International Criminal Tribunal for Rwanda to try the most senior leaders responsible for the crimes of genocide, crimes against humanity, and war crimes. This was part of a pilot project by the international community that was already underway in the Balkans that sought accountability of major figures responsible for mass atrocities and justice for victims. For in the words of former Secretary General Kofi Annan, there can't be real peace without justice. Yet, as we know, in Nuremberg and Tokyo, international prosecutions of mass crimes and the evidence collected to support them are by necessity selective, targeting the most significant perpetrators of what are deemed to be the most significant crimes. So with this background, I'll now hand the floor over to Stephanie, who'll speak to the patterns that emerged when we look within and across these three case studies.
Okay, so the second pattern that we see when we think through these three very different case studies has to do with the way testimonies of sexual violence emerged in the record at the time. And here we note a handful of similarities. In all three of these cases, testimony of sexual violence, when it emerges, is incidental to a broader political project of the inquiry. We also note that in all these cases, the testimony of sexual violence that does emerge is eventually and quickly subsumed by the broader political project of the inquiry. The testimony is shaped by the investigative process itself. We could write a whole paper just on that. And the testimony gains significance, the testimony especially of women victims, gains significance when it is instrumentalized to serve those larger objectives of the broader political project. And then Rosemary and I note one other pattern, which is true of the US and Rwanda, but not necessarily of the 17th century case, which is that perpetrator witnesses and defense attorneys, which exist in these cases, produce secondary or counter narratives. And in some cases, those narratives can eventually emerge as the dominant ones. So this is a troubling and interesting element. So we clearly see the first four of these elements in the 1641 depositions that Jane knows so well. The depositions record acts of sexual violence, especially mutilation and ritual humiliation associated with stripping, alongside of robbery, assault, and captivity. After relating their losses, the deponent first provided an account of what she has seen and experienced, so her eyewitness evidence, followed by what she heard from others, the hearsay evidence. And that hearsay evidence tended to be vaguer and often included more sensational claims and rumors. The eyewitness testimony often included the names of her assailants, their actions, including the sexual violence that was perpetrated, and the women's words were recorded here in the testimony. So in total, these become deeply personal narratives of trauma. And this is another thing that repeats across all these cases. These propagandists in 1641 used the experiences of female victims to characterize their perpetrators as monstrous and barbaric in order to advocate for a radical policy of retribution. And across the centuries, you can see that these narratives have been used at moments of political crisis, including as recently as during the Troubles in Northern Ireland, to whip up anti-Catholic hysteria and to justify extreme measures. Well, surprisingly enough, even when you look at the 19th century case that I know the best, you see very, very similar patterns. The inclusion of witness testimony makes the Klan investigation an absolutely irresistible source for historians seeking to uncover subaltern perspectives. But when we use it, it's crucial to recognize the political logic of the evidence that is produced. Testimony of sexual violence is actually very rare in these records because few women are called to speak. Of 856 witnesses, only 42, or around 7%, a number quite similar, I think, to what Jane found. Only about 7% were women, and only 8 of those 42 testified to sexual attacks. Most of what was actually reported of the sexual violence against women came from male witnesses, who also, and more frequently, testified to attacks on other men, including barbaric acts of castration and genital mutilation. And this is not something well developed in the literature. Confronted with testimony of sexual violence against women, the Republican members of the committee rushed past it and strained to tie it specifically to the Klan conspiracy. This was no easy task given the historical continuum of white men's sexual coercion of enslaved women and their violent reassertion of that right that they claimed in the face of these newly freed Black women's power to resist. In the investigation and in the trials that followed, the relentless focus on Black men's voting rights subsumed both the evidence of sexual violence against women and with it, really, the broader nature of the assault on the Black community. The Klan's violence against women was gravely underreported, but there can be little doubt that it figured prominently in the arsenal of weapons they deployed to instill terror in their victims and in the African American community at large in the US South. Sexual regulation was the very core of white supremacy then and now, involving the policing and enforcing of racial boundaries through sexual violence. Over the long run, white Democrats on the committee, the minority, proved more successful at instrumentalizing sexual violence against women, building a propaganda machine that churned out stories about Black rapists and vulnerable white women to serve their political project of restoring white rule. And this reached mass international circulation, something you would probably recognize by the end of the century with the 1915 film, Birth of a Nation, which is based on the novel The Klansman, whose subtitle is A Historical Romance of Reconstruction. So this is white supremacist propaganda 101. And so now we turn to our third case study, what Rosemary knows so well. In the initial indictment in the Akayesu trial, like all indictments issued by the International Criminal Tribunal for Rwanda during its early years, there was not a single charge for a sexual crime. While mass sexual violence was effective in mobilizing the political will for the creation of an international tribunal, it was incidental to the broader aims of the international prosecutor, who was focused on accountability for the so-called big crimes of genocide and crimes against humanity. It's widely recognized that the intervention of women's advocacy groups during the Akayesu trial or case led to its groundbreaking ruling. Hearing extensive sexual violence testimony in the trial, they lobbied the office of the prosecutor and submitted an amicus brief arguing for the amendment of the indictment to include those sexual crimes. The celebrated conviction of the mayor of Akayesu for rape as a constituent act of genocide. However, the fact that it was entered into the indictments meant that the testimony of sexual violence was elicited and shaped to fit the criteria, which was to convict for orchestrated and systemic crimes, genocide, and crimes against humanity. And here is very consistent with the pattern of the Klan trials. The indictments, the charges have to meet the indictment. So here, in this case, rape was understood, one of the consequences was that rape was understood through the lens of ethnicity, and its victims then were Tutsi and female. The testimony of sexual violence that appears in the Akayesu and many other judgments was elicited and subsumed within the big crimes, producing ethnic, in the end, producing ethnic over gendered narratives of sexual violence in the Rwandan conflict, narratives given traction by the failure of the tribunal to try any Tutsi perpetrators. Now, the International Criminal Tribunal for Rwanda's low conviction record of sexual crimes is stunning, given the scale of sexual violence during the genocide. Yet the Akayesu case and subsequent sexual violence judgments were nonetheless instrumentalized by the tribunal as legitimizing accomplishments within the International Criminal Court's mixed legacy. But it was also instrumentalized by feminist lawyers as precedents to codify sexual crimes in the 1998 Rome Statute, establishing the International Criminal Court, and to advance the women, peace, and security agenda in the United Nations. And Rosemary notes that while there is a classic counter-narrative of victor's justice that emerges about this case, modernized to include the vested interests of NGOs, it has received scant public or scholarly attention up to this point. So this brings us actually to our fourth and final section of the paper, moving into the conclusion. And here I'll turn it back to Jane.
Thank you, Stephanie. So I'd like to say a few words about the methodological contribution of this study. Sexual violence testimony has long been overlooked, and from a historical viewpoint, we have a lot of work left to do. But from the 1970s onwards, there's been a growing body of feminist scholarship that focuses on sexual violence in conflict, some of which draws in part from testimony that's located in the transcripts, documents, and judgments of inquiries and trials such as those that we've described and others like them. That scholarship gives excellent explanations for why sexual violence is often eliminated from historical and national memory, especially related to conflicts. And there have been many excellent papers actually in this conference on that point. So, I mean, it couldn't be more relevant. It has also provided theoretically informed ways to understand the particular traumatic effect of sexual violence, not just on victims, but entire communities across generations. Yet when testimonies of sexual violence have successfully gained scholarly attention, it has usually been part of broader subjects, converging the evidence of sexual violence with powerful political social narratives of urgency in the present. As with Stephanie and Rosemary's case studies, this work is often symbiotic with projects at the intersection of feminism and human rights, and anti-racist and more broadly defined social justice movements. So this all poses questions about whether the pattern we described of erasure and subsuming of evidence of sexual violence from records of conflicts is an ongoing phenomenon. What, if anything, our study, our comparative perspective can add to feminist scholarship on that particular issue. That we think turns on the case of Rwanda and the way we place it in the historical framework and perspective of prior, very, very different conflicts. So the first thing is to recognize that Rwanda was a historical turning point in the long history of sexual violence as a tool of political terror in armed conflicts. As Rosemary explained, the failure of the International Criminal Tribunal for Rwanda trials to indict for rape, despite widespread public recognition of the scale and sexual atrocities committed during the Rwandan genocide, the prosecution record of sexual violence by the tribunal was poor. Nonetheless, it still had a considerable impact on creating a legal and institutional framework for accountability for sexual violence in conflict at the International Criminal Court and the United Nations. Along with the sexual violence convictions, and I'm going to abbreviate it, the ICTY and the Special Court for Sierra Leone, IK Yesu and other ICTR cases represented a new opening in history. The muted testimony of sexual violence in conflict had become amplified at a time after the fall of the Berlin Wall, when supranational governance was reinvigorated. The international human rights regime was expanding rapidly, and international law had revived legitimacy. This allowed for the creation of international criminal courts and tribunals, but also an awareness and encouragement to use the lens of accountability to newly open up the field, to newly open up the study of the past. Feminist activists were important actors in the process. Some of the women who collected evidence of sexual violence would later become staff or consultants for the Office of the Prosecutor at the ICTR, or serve as expert witnesses for trials, as well as authors of contributing to and shaping the scholarship on sexual violence and conflict. The official recognition of sexual violence as a war crime in the late 1990s generated a new round of feminist scholarship that fed back on analysis of historic conflicts, including ones that we are now writing about.
Jane has just mentioned that taken together, the Yugoslavian and Rwandan cases opened up this new moment in history, and possibly in the writing of history, folding back onto prior conflicts. And here I'm very curious about whether Irish historians of, say, the Civil War in the 20th century see that or anywhere in the footnotes in the things they write or read. But to take one example that I know very well, the two best accounts of the sexual violence of the Ku Klux Klan, published in 2002 and 2012, so subsequent to the 1990s, draw on International Criminal Court decisions and human rights law, and on the United Nations Women's Peace and Security Agenda, passed in 2000, as well as feminist scholarship on the genocides of the 1990s in Yugoslavia and Rwanda, as legitimating similar perspectives on past atrocities. But the patterns that emerged from the cases we studied and the attendant challenges of identifying perpetrators and seeking accountability for sexual violence and political conflicts, the ones we saw in the past, still holds. That contextual recognition that we have been stressing of the way evidence and testimony is subsumed in and by the play of power in any given political legal context is no less relevant now in the 21st century than it was in the 17th or the 19th century. And this is something that comes through very clearly in Rosemary's account of the Rwandan case. The global project that seeks justice as a prerequisite for peace, not surprisingly, embraces the notion that fighting impunity deters future atrocities. This is what the Klan lawyers said when they went after these guys in 1871. Post-genocide Rwanda has enjoyed peace and impressive development under the authoritarian rule of Paul Kagame. But as Rosemary notes, if you widen the lens to look at the Great Lakes region, where many combatants in the genocide are active in militias, extreme rates of rape and sexual violence are well documented. And while the counter-narrative of Victor's justice may get little scholarly notice from lawyers, history suggests that it can resurface and provide powerful legitimation for violent actors and movements, as it did in the U.S. South after the alleged defeat of the KKK. So the literature all emphasizes the defeat of the Klan. But by the turn of the century, Black voters in those states had been forcibly disfranchised, racial segregation enforced, and the Black community again terrorized by an epidemic of mass public lynchings of alleged rapists per the earlier pro-Klan script. This is the period W.E.B. Du Bois described as a descent into hell. So it's here we think that our analysis might stand to make a methodological contribution, and we anxiously await your opinion about that. As we concluded, across 4 centuries, 3 continents, and very different conflicts, you can see a strong pattern of how evidence of sexual violence is underrepresented or overlooked in the transcripts and records of investigations of political conflicts, because it was incidental, subsumed, and instrumentalized to a broader political project that had little to do with women's particular interests or the crimes that had been perpetrated against them. And given the focus on the recuperation of evidence of sexual violence in feminist scholarship, an admirable endeavor, which I subscribe to, it is a reminder that we need to keep a critical perspective on the sources. Because of the gravity of the crimes and the seduction of the sources, like the Klan, ridiculous pairing of words, but the sources are irresistible to historians, feminist historians and legal analysts can take liberties, focusing on the testimonies that do make it into the record, reproducing them in anthologies, elevating them over the counter-claims. All of this can inadvertently convey a false sense of their number in and centrality to investigations of past events and efforts to bring perpetrators to justice. Working with contemporary testimony, as Rosemary does, has other challenges, as many feminist legal scholars have been involved themselves in the courts and the cases that they're also writing about. The firewalls that are normally erected in objective scholarship are difficult to maintain with the fluid change of roles between advocates, scholars, and professionals who are themselves stakeholders in the political project of international criminal justice. In other words, the 3 very different cases we offer here suggests the need to keep sight of the political construction of the archive. We see this as key to properly assessing the nexus of power relations within which historical and contemporary actors operate. What we're trying to say, that is, if nothing else, our study reminds us of the inescapable limits of the evidence which shape any pursuit of justice, past or present. Thank you.